You think you're safe. You've been in business for a number of years, you've gotten by this far. But that doesn't necessarily mean you're safe from a trademark infringement letter. And unfortunately, most people don't realize this until a trademark infringement letter hits their inbox.
We'll even share the true story of how a food truck owner lost everything by not protecting their brand.
It is never too early to get your trademark protection, but it can be too late.
A lot of times with the brand new businesses, people just simply think that they're too small to even matter to anyone. So when they receive the cease and desist letter, a lot of times people are just pure panic.
So we've given a couple of steps here. Let's break this down into a few action steps, things that people should do if they receive a trademark infringement letter. So step one, you're going to run a search through the USPTO. So that's first step. Second step.
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative asset.
I'm Holly McFall, and I'm with Melissa Jeda. We're the co-founders of SecureMark Legal. With over 30 years of combined experience helping entrepreneurs and established companies protect their brands, we've seen exactly how fast a small mistake can spiral into a 5-figure rebranding nightmare. In this episode, we're breaking down the real-world trademark pitfalls that blindside business owners every day. If you've just received an infringement notice or want to make sure you never do, you'll learn what it means, what your legal options are, and how to navigate the road ahead without tanking your brand. We'll even share the true story of how a food truck owner lost everything by not protecting their brand.
It doesn't matter if you're a brand new business or you've been in business for a number of years. Trademark infringement affects us all. It is never too early to get your trademark protection, but it can be too late. It really should be part of the foundation of your business, making sure your brand is protected. You're starting off on the right footings to be able to build that brand and have a strong foundation in order to be able to continue without this worry. We see a lot of clients that get trademark infringement letters and they kind of fall into two groups. They've been in business they're a new business. They've been in business for a few years, typically, let's say under 3 years. Or they've been in business for a number of years, and the reaction is always different. I mean, you get a trademark infringement letter, it's like panic sets in. And we understand that panic. We get that. That's a lot of scary worry. And some people ignore it. They're like, whoa, wait a minute. I can't handle this. This might not be real. They'll send me a second letter. We hear that a lot. I only got one letter. Are they going to send me another letter? Not necessarily. They may actually go directly to litigation. And there's some things that we can do about it. For the ones that have been in business and just started, they're like going to be on top of it. And then the ones that have business for a long time, 10 years plus, they're like almost like, whoa, wait a minute. What are they doing? Why are they sending me this letter? What did I do? Well, what did they do?
Well, that's where you need to start with a little bit of research. Maybe you've never even heard of this company before that's sending you.
What is a trademark letter? What is this infringement letter that you got? You open it up and it's like pure panic. I mean, some of these letters are nice. Some of these letters are actually funny. Some of these letters are like super strict and super scary. No matter what kind of letter you get, it's not something that should be ignored. You shouldn't think you're going to get a second or third chance to respond to this letter. A trademark infringement letter is basically another company saying that you're using their name, their brand, their logo, their slogan, or something that they have registered with the United States Patent and Trademark Office. That is how we protect a brand. We register that trademark, make sure that no one else has a confusingly similar mark to ours, and we register it through the USPTO. And then you receive a letter that says, wait, stop, cease and desist, because you're infringing on my brand, and I have the right to stop you and sue you. So don't panic, even though it's the first natural reaction. You want to make sure that you actually take that letter seriously. You look into it and you go through the steps and make sure that you are doing what is necessary to protect your brand. It's not always the be all and end all. So don't panic when you see the letter, but don't also ignore that letter. We've seen both new businesses and existing businesses receive trademark infringement letters. Why is that?
Well, a lot of times with the brand new businesses, people just simply think they're too small to even matter to anyone. So when they receive a cease and desist letter, there are a variety of different responses that we see. A lot of times people are just pure panic. They get this letter and they're like, they are demanding all of this money. They're demanding that I stop this, wonderful business that I just started, that I've always wanted to do my whole life. And why do they care about me? What can I do? Do I really have to listen? Do I really have to stop? If you have that reaction, the best thing to do is just take a breath first. We have to research what's going on. We have to look and see who this company is. Have they been in business longer than you? Do you have a registered trademark? Of course, if they do have one, we have to look at when did they get that trademark? When did they start using the brand name? Was it before or after you started using yours? Who has priority? That's the biggest question. Maybe they don't know enough about you and they've made a mistake. Maybe they don't know that you've been in business longer than them. In which case we can respond and, fight that letter for you.
Okay, so we've given a couple of steps here. We've jumped kind of ahead. Let's break this down into a few action steps, things that people should do if they receive a trademark infringement letter. So step 1, we've already said, don't panic. Step 2, don't ignore. Okay, those are really the basics. But you need to go and run a search, verify that information that's in that letter. We need to start looking and breaking it down into components. So first, you're going to run a search through the USPTO. If you simply put in your search engine, USPTO, trademark search, you're going to get a link to the USPTO. Don't go to someone else's website. Go directly to the source of registration. And it's a search engine. It really is something that you can go through. You can either look directly and type in the name exactly as it is. Most trademark infringement letters are going to have a serial number or registration number. You can search by those numbers. So now you're going to have that trademark in front of you. So that's first step, search. Second step, verify. Third step, look at the date of first use. Fourth step, we're going to look and talk about goods and services. So first step, you want to do that search. You want to go directly to the USPTO and you want to type into your search engine, USPTO trademark search. It's just like any other search engine. You can search it exactly, verbatim, the exact mark as it is. Most infringement letters will have a serial number or registration number. You can search it that way. That's how you verify that they actually have a trademark. You've looked at this trademark and now, yes, they have a trademark. Yes, it is the same brand name that you're using or confusingly similar brand name. Remember, it doesn't have to be exactly the same. And that's the first step that you want to see. You've verified it.
Then once you have searched and maybe you found that they do have a trademark registration, now you need to look at what's called date of first use, which is listed in every trademark application. That will tell you when that business owner is claiming they started to use that brand name. So look for that date of first use, compare it to yours. See if it's before or after you started using that brand name.
Even if the date of first use is after yours, it doesn't necessarily mean that you can say, okay, I can ignore this letter, because you can't ignore this letter. There are legal ramifications, deck actions, there's other steps that can be taken by an attorney to stop that. But if their date of first use is before yours, now we want to look at what is that brand doing? What do they sell? What service do they provide? We want to start looking at what class they're in. Are you going to be the same? Because you can have two of the same trademarks for the exact same name. Think of Dove chocolate and Dove shampoo, Delta airplanes and Delta faucets. You are not confusing those two brands. You are not going to buy Dove chocolate. You're not using it as shampoo. So though they are sold both in a grocery store, there are different aisles of that grocery store. So you have different consumers for a different purpose. So you want to look at that goods and service and analyze it. So now you've done your search. They've got a registered trademark. It's not abandoned. You've looked to make sure their date of first use is before yours. You've made sure that their goods or services are similar.
So once you have services that brand is providing and compared it to your own, is it the same thing? Do you believe that a consumer would likely be confused between your two businesses? What differences can you point out to think of an argument against what they're claiming? So even if like Melissa said, even if the two brands are the completely same down to the letter brand name, if you can prove that there is no likelihood of confusion, that there are significant differences between the goods or services that are being provided by the two different companies, you can overcome the trademark infringement that they are claiming that you've committed.
One of the other considerations that sometimes our clients are like, but they're spelled differently. They're not, I don't spell my name the same way, or I have other words in my mark that they don't have in their mark. How do I know what raises to a level of likelihood of confusion? It's this subjective standard of how do I know I have a different spelling, or I'm using, a CH opposed to a T or something along those lines for the, to spell out my name. Or maybe I'm not even using vowels in my name and they're using vowels in their name. That's one of the considerations. Is that confusingly similar? How do we judge that level of confusingly similar?
One of the main things you would look at is how people would pronounce the name. If they would pronounce it exactly the same or very similarly, or it could be pronounced very similarly, then that's almost the same thing as it being spelled the same. It's definitely not a requirement for it to be the exact same spelling in order for confusion to arise.
Continuing to talk about this valuation of this claim, we've got this letter, how, we're evaluating what the other mark is and how related they are to our mark, how similar they are to our mark. Part of that evaluation is this still in business? Just checking the USPTO is not sufficient. You got to go beyond that and do some more of your own research and looking at them. Not everyone has an online presence, but 90% of the world has an online presence now. And that's a great way to check it out. Are they still in business? I mean, why would you send a cease and desist letter if you weren't? But it's still worth going and checking out, seeing what they are. Maybe you guys are the same, but they sell locally. They sell to a small area and you sell to another area. So you're in the Midwest and they're in the Southeast. Maybe we can work out some kind of agreement. Maybe our social media channels are different. It just because, okay, yeah, I've got a similar name. Yep, they've been in business longer than me. What do we do? This is all part of evaluating what their mark is. You want to look at what their presence is, what they sell, what they do online, how they kind of go back and forth in that. We've negotiated a consent agreement, it's called. We are going to cooperate together, we're going to work together, and we're going to coexist in different spaces, in different locations. A possible outcome to these infringement letters. There's also a lot of other things in evaluating your position. Talk about the fact that most of these letters are friendly. Now you've evaluated what they are. Talk about that. A lot of times companies just want you to stop using their brand. So now maybe we're not looking at litigation because we're stopping now. Talk about maybe they're just asking you to rebrand. Can you negotiate that? What the infringement letter is actually asking. Now we verified, what is that infringement letter actually asking us to do?
So now that we have verified the claims in this letter, now we have to look at, what are they actually asking in the letter? Not all letters are, big and scary and asking for lots of money and things like that. A lot of times they just really want you to stop using the name. And so we can look at, pretty simple ways to go about that to bring a resolution to the friction that has been caused by this letter. If we do agree after all of the research that there is confusion, they do have the better position. We can talk about, ways to kind of ease into the stopping of the using of the brand. Probably looking at rebranding at that point. You're not necessarily having to shut down your business. You just maybe need to come up with a new name.
It can get costly though too. It can, rebranding, all of that process. I mean, that alone is not quick. It doesn't, we didn't build our business overnight. That's not a super quick process either.
Very true. Yeah. So you may very well need time to make a rebranding happen. It's expensive. You probably don't have the money to just do it right away and turn around on a dime and the next day start working under a new name. And, practically speaking, you couldn't really do that even if you could afford to, because your customers would be confused. You have advertising possibly already out there that you can't just stop right away. Business cards, flyers, advertising materials, all of those things that will need to be redone in the rebrand.
Even signage, hang tags, even contracts possibly. I mean, your brand name and your company name doesn't need to necessarily be the same, but maybe a contract with your retailer, your suppliers, getting your manufacturers to change the brand name that's on your packaging. All of that takes time. And all of that's part of that consideration when you're evaluating their claim. Hopefully they're not asking for money. If we really are infringing, hopefully they're just asking us to rebrand. And that kind of comes down to negotiating it.
Right. And even if they are asking for money, that doesn't mean that that has to be part of the end result. That's part of the negotiation. Maybe we say, our client literally cannot afford to pay you anything, but they're willing to work with you. Here's what we're willing to do. And a lot of times, they have to look at it from a business standpoint as well. It's always a business decision how far you want to push something like that. They'll end up spending more money paying their attorneys to keep going back and forth. And so, we can usually reach a pretty good resolution fairly quickly as long as both sides are being reasonable.
And we send these cease and desist letters. We get them for our clients too. Client, discovers a brand. We discover a brand in our watch service through their registration. And it's always easiest to get it when a brand is like brand new. Like someone goes ahead and files a trademark registration or opens up a new business and we get notice of it and it infringes on our client. Like that rebrand letter is a whole lot easier. We believe in sending nice, kind letters that get your attention, know that we're serious, but at the same time is giving you an option because most of our clients want to build a business. Sometimes we can build a business together too. We don't want to just stop you, but we also don't want you infringing and building off of our reputation when you don't own that trademark. That's a problem. So we've talked about the different steps of what happens when you get a trademark infringement letter. I mean, we really are talking about trademark infringement here. That's something we have to be specific about. We're not talking about copyright infringement. We're talking about trademark infringement. And the process really is don't panic and don't ignore. Secondly, make sure you verify that claim. Make sure that claim, they actually have the right to the ownership that they say they have, that the mark is confusingly similar to yours in name and appearance, that it's the similar goods and services, and that they're still in business. And then once you know that their claim is verified, you want to evaluate what that claim is worth. What are they asking me to do? How can I negotiate that? Where do I have standing? Where do they have standing? And how can we work together to get this resolved? Because trademark litigation gets expensive really fast. I mean, we've seen a few like nasty letters, like really nasty ones where we're like, ooh, they're coming at us strong for no reason. And then we have to fight back strong. And that gets costly really, really quickly, where we can also, work together to build. It seems like building businesses should definitely be more friendly. It's still a competition. We are still business. It's still, competing for our customers, but it doesn't have to be nasty. I can think of a few nasty letters we've gotten, Holly.
Yeah. And they don't always, turn out the way that you might expect. A lot of times people just take a hard line approach from the beginning. Maybe they think that that's what's necessary to get somebody's attention, but they don't really have the intention of following through on all of those threats. So you kind of have to just take it with a grain of salt, again, take a breath and just say, let's figure this out and, de-escalate the situation if we can.
I'm sure everyone wants to hear about our most nastiest one. And I think the saddest case that we've come with is Holly talked about in the beginning, this food truck. They got a cease and desist letter and they ignored it. And they got one. She says she remembers receiving it in the mail and thinking, oh, this is a joke. It was, she said it wasn't very professionally written and she didn't think it was a big deal. And this food truck was a mom and pop food truck. They only ran the food truck on the weekends. Football games, local events. They were a small food truck in a small South Florida town, and they only served dessert. So they thought, okay, I'm too small for anything to happen. They registered with their state, just like everyone else does. They formed their business, registered with the state. State said the name was fine. They got their FEIN number. They thought they were doing everything correct. They had no clue about trademark infringement. They had no clue about trademarks, let alone knowing that they needed to go ahead and file for a trademark. And then they get litigation. And that litigation had so many zeros. They were like, that's more money than we've made in the 2 years we've been in business. It was a brand new business. But the craziest thing about this one is how they found out about the infringement. They didn't have a social media presence. They weren't online. They were a local food truck thinking that nobody can touch me. And why would they? I'm too small. The craziest thing about this whole litigation is the way that the restaurant that was in another state, it was in Texas, found out about the food truck was that someone had left a positive Google review, a 5-star Google review saying, I can't wait for you. I mean, I'm not verbatim, that they are looking forward to eating this dessert from the food truck in South Florida at their Texas restaurant. And the Texas restaurant owners were like, wait a minute, what food truck? And they sent a cease and desist letter. It got ignored and they went right to litigation. All was because of a positive Google review. It wasn't even like a negative thing or a bad consequence of someone ruining your reputation. It was a positive Google review. That's what's so scary about this, is that no matter how small you are, someone is going to talk about you.
Today's episode, it's this. Waiting until you get an infringement notice is like buying insurance after your house catches fire. Trademark protection isn't just a formality, it's a strategic necessity.
Trademark protection is part of the foundation of your business. It's part of setting up and making sure your business is secure so that you can continue to grow. It doesn't matter if you're new. It doesn't matter if you've been in business for a long time. You need to make sure you build that foundation. The longer you've been around, the larger your footprint gets. We talked about a food truck today that had just been around for a few years. But if you've been in business for a number of years, your presence gets bigger and bigger, and the risk is higher and higher. The cost of rebranding is more and more.
We're SecureMark Legal, and we help businesses do exactly that. If you're ready to get serious about protection, we're here when you are. Reach us at SecureMarkLegal.com, phone number 239-323-0702.
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets. While we are lawyers, we are not your lawyers. So nothing contained in this podcast creates an attorney-client relationship or constitutes legal advice. The views and opinions of guests on our show are not necessarily those of SecureMark Legal and are provided for informational and educational purposes only. This presentation is protected by U.S. and international copyright laws. Reproduction and distribution of the presentation in whole or in part without written permission of SecureMark Legal is prohibited.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.